The First Amendment states that the press is free to publish stories without government restriction, but there are regulations to this freedom. Privacy of the individual is a problem often dealt with in courts. If a newspaper publishes the name of a juvenile delinquent, is the child's right to privacy invaded? Newspapers have always been much more careful when writing stories dealing with minors than with regular adults. Juvenile delinquents, children under the age of 18 who have committed a crime, can be a difficult topic to cover. When naming these children in the media, a reporter must consider the federal and state law. Ohio law states that naming juvenile delinquents in newspapers is lawful, but some newspapers choose to follow their own ethic rules and not name children in the paper.
Generally, we won't name juveniles unless they are charged, unless it's a serious offense or they have been charged as an adult.
Okay.
If someone under the age of 18 is arrested or charged with a misdemeanor, we won't name them. If they're charged with some kind of felony charge, we'll take.
In 1979, the Daily Mail Publishing Company ran a story about a juvenile who was arrested for allegedly killing another minor. The publishing company was sued for publishing the name of the suspect juvenile in the paper, because according to a West Virginia statute, it is a crime for a newspaper to publish without the written approval of the juvenile court the name of any youth charged as a juvenile offender. Smith v. Daily Mail Publishing Company went to the U.S. Supreme Court, where it was decided that the state cannot restrict a newspaper from publishing a juvenile offender's name unless the restriction serves a substantial state interest. And in the case of Smith v. Daily Mail, there was no reason to conceal the juvenile's name. All newspapers establish their own policies on naming juvenile delinquents in stories, and these rules vary from state to state.
And so on and so forth. It is not, I came here from Florida. In Florida, it was against the law unless someone was charged as an adult to list their name. In Ohio, you can do it. The courts would prefer that you don't, but there's no legal reason why we can't list their name.
Deciding whether or not to name a juvenile in the newspaper can be a difficult decision. If a case arises that is not typical and does not follow the normal guidelines of the newsroom, it is important to decide what will be the best way to represent the juvenile in order to make sure the public is getting the most out of the news.
Say for example, it's 9 o'clock in the morning and we find out at 2 o'clock in the afternoon that there has been a case where a 16-year-old has been charged with stabbing someone. This is strictly an example.
Yes.
We will sit down, we'll have a discussion, we'll find out, we'll talk to the investigators involved in the case, and we'll decide whether or not we have a good enough information. Do they think they're going to take this to a grand jury? Will we go ahead and do it? Generally what we'll do is we'll explain to our readers in the newspaper on our website if we're going to name the person who's been charged, or if we don't. Oftentimes we'll say we're not naming this child because he or she has not been charged as an adult, and our policy is to refrain from that. So we'll try.
In 2007, 15-year-old Robert Jobe shot and killed a Toledo police officer. He was tried in court as an adult and sentenced to life in jail. The Toledo Blade decided to name him in the paper because he was tried as an adult.
In the case of a 15-year-old a couple years back who was charged and arrested soon after a police officer was killed in Toledo, we named him right from the outset, partly because they had arrested him within an hour or two after the shooting. He, for the most part, confessed to the crime, and then when it went through the courts and then they charged him as an adult, we followed the whole process and named him. But if someone is stopped for any kind of moving violation in the car or something like that, we'll generally just say a 16-year-old, 15-year-old, or so on and so forth. It is. I don't think so. I think I like to fix some things that are broken, but I don't think there's any reason why we should do it. If a person, say for example, if a teenager is involved in a car crash, we'll name them because they're charged as in a car crash. But often, if they're charged for a minor thing, it's not worth it. It's something that won't last. Why sully the record that they'll have 5 or 6 years ago when it may be thrown out? So it's not necessary to do that. I think the policy that we have and the guidelines we follow are good ones. And
The Juvenile Delinquency Act was established by federal courts to protect the First Amendment rights of the press and the juveniles being tried in court. It states that the government is allowed to hold a hearing in federal court for a person who has committed a crime under the age of 18. Public access is permitted on a case-by-case basis according to the courts, and all juvenile records are closed to the public until the case is moved to a criminal court. In 1995, 3 juveniles were tried for hate crimes under the provisions of the Juvenile Delinquency Act. The Globe newspaper wanted access to the juveniles' trial and proceedings, which is not prohibited under the Act. The district court restricted all public access to the trials, but allowed the Globe newspaper to review court documents. The Globe claimed that the First Amendment right to juvenile proceedings was violated by not allowing public access to the trials. The U.S. Court of Appeals found that the Act may authorize the closure of juvenile proceedings, but the Act does not mandate them. In the case of the U.S. v. 3 juveniles, the court's order to close the case was justified. With the overwhelming use of internet media sources and broadcast television or other media outlets, it can be difficult to control the amount of information released to the public about juvenile delinquents. Should there be more restrictions on other media sources?
no, there's no difference now, because our canvas, our world out there is so much different than it was 10 years ago because of the web. Because of the World Wide Web, people can get information from all sources. And once you get your name out there, whether it be in the newspaper or on a website, it's going to be scraped by all kinds of search engines, especially Google, that it will be worldwide within a couple minutes. I mean, I put your name on the web, you'll be a folk hero within 20 minutes after your name's on the web.
When deciding whether or not to publish a juvenile delinquent's name in the newspaper, online, or on broadcast television, there are multiple things that need to be considered. Who is served by identifying the juvenile? How newsworthy is the story? What is the juvenile's history? And would others be harmed if the minor was not named, or if the rumors were allowed to circulate unchecked? Just as professional journalists must follow these rules and regulations about naming juvenile delinquents in the paper, student journalists must also go through the process of deciding whether or not it's a good idea to name juvenile delinquents in a student publication. Following these guidelines, students can have discussions with their peers and mentors to decide whether or not it's a good decision to name a juvenile delinquent in their story.
That is, if it's a serious crime, certainly have a discussion with your supervisor or your of any kind of publication or media organization at your college, and discuss it and really have a serious pro and con discussion about it. I would be more I would err on being more conservative than liberal. And with that being said, if a juvenile is charged as an adult, then they should suffer the consequences And then I have no problem naming it on the web, in a publication or anything, even in student publications.
The freedom of the press given in the First Amendment allows journalists to report stories without fear of repercussions. Ohio law may state that naming juvenile delinquents in the paper is lawful, but it is important that journalists follow the policies instated by their paper and maintain their integrity when naming juvenile delinquents in all circumstances. As Frank said, it is all worth it if naming one juvenile delinquent saves another juvenile later on.